When decisions for the kids are tied to how much your ex has to pay you as a result of that decision, then vague parenting plan clauses that say things like by agreement are not going to cut it. Hey, if you're new here, I am Taylor Wins. I'm a divorce coach. I'm a Minnesota licensed divorce attorney, and I'm a divorce mom of four. And anytime a decision for the kids is tied to money, that means that logic and empathy often leave, right? If you're going to make a decision for the kids and that decision directly affects what your ex-spouse is going to have to pay you, expect it to be a recipe for disaster if it is not clearly defined. So in this video, I'm going to walk you through three common parenting plan clauses where people write something really vague, like by agreement of the parties, or in the best interest of the children, or the parties will just agree at some point in the future that are actual setups for chaos and conflict. So let's take a look at the first one. The first one is sports and extracurriculars. Okay. It's going to say something like the parties will split 50% of agreed upon extracurriculars for the benefit of the kids. And that is something that's setting you up for issues in the future because we don't have anything listed about like what the extracurriculars that the kids are already doing are. If they're already doing them, are we going to just maintain the status quo? Like that doesn't need a new agreement every time, right? If we've been doing soccer for 5 years and we get to year six, and now does the one party have the opportunity to say, I don't agree, even though they've already been doing that soccer for 5 years, right? So that's going to be an issue. And then by agreement, right? So what if a child wants to go out and start something new? Okay, I've been playing soccer for 5 years. Now I want to go dance. Well, by agreement is super vague, right? One party then can say, I don't agree with dance at all. I don't agree with dance at this location. I don't agree with this type of dance. And there's no further provision in there for if one person doesn't agree, what's the tiebreaker? How do we resolve that lack of agreement? And where does the child's interest or the child's input play into whether or not that sport or extracurricular activity is going to happen? Right? So you have to have something far more specific in there when it comes to paying for these types of things, right? A much better clause, like I already alluded to, would be a clause that kind of gets into maintaining the status quo. So if a child is already doing basketball or cheer, or whatever it is, at the time that you separate or enter into a custody agreement or a modification of custody, then you want to go ahead and just put that in there, right? The child does cheerleading. The child will continue to do cheerleading at whatever the location is, for the duration or forever long, however long. And then if there's some event, you might want to name the event, right? That necessitates the need to switch cheerleading gyms, or if the child stops cheerleading or something like that, then what happens from there, right? So if we have to switch, then each party is going to set forth three new gyms or something like that. Or each party is going to exchange the gym closest to them and they're going to compare rates and they're going to pick the one that's most cost effective. But you see how there's a lot more detail that you could put in there that's going to stop these blanket like denials of the child's ability to participate in that sport or that extracurricular. A lot of times, again, it is tied to the fact that it has to be paid for. So a lot of parents would agree that sports and extracurriculars are really great for kids if they were free. But now that, there's an expense tied to it, a lot of times parents will throw up an objection. So that's why it's so important that if something is already happening, that you put language in there about maintaining the status quo so that a parent can't withdraw their consent for no reason other than they don't want to pay for it anymore. The same goes for things that aren't sports, right? Like theater camp, summer camp, horseback riding camp, the school trip to Washington, D.C., a field trip that costs a bunch of money, band, choir, whatever it is, right? The same applies to those things where a lot of times they cost money. And if they were free, nobody would argue. But now that it costs money and one parent may have an affinity for that specific type of activity where the other parent doesn't, then the parent who doesn't care for it may withdraw their consent or withhold their consent because they don't really like that activity. So why should they have to pay for it? And oftentimes the conflict starts because the child will go to one parent and they'll say, hey, I want to do show choir. And that parent will say, sounds great, honey, I'll sign you up for show choir, thinking it's not an issue because the child is initiating it and the child is asking. They go to sign the child up for show choir, they pay the $500 deposit, and then they reach out to the other parent and they say, hey, Susie has expressed it as a desire to be in show choir. It's $500. I'm going to pay for it, and then you'll need to reimburse me $250, and boom, there's conflict. So we definitely want to make sure that there's some sort of protocol in your parenting plan as well about what is reasonable notice to the other parent. So if Susie comes to you and says, I want to do show choir, how long do you have to reach out to the other parent and ask for their consent? How long does that parent have to give or deny their consent to participating in show choir? And then if it is agreed upon, how long from the time that parent one makes the initial deposit does parent two have to give or enter some sort of reimbursement, right? So lots of things to think about when we're dealing with these types of issues. So again, you want to make sure that with sports and extracurriculars, and really with anything that we're going to talk about in this video today, that there is some sort of protocol for giving notice to the other parent for a new activity, for continuing the status quo of things that have been going on for a long time, actual percentage shares of how much each party is obligated or required to pay. What do we do if people don't agree? How do we resolve disagreements? Where does the child's input come into play? And then if one parent incurs the expense, how long does the second parent have to reimburse the parent who incurred the expense? Now let's move on to item number 2. And these are the unreimbursed and the uninsured medical expenses, where sometimes there's a little gray area about whether or not this is a required medical expense, whether something is deemed medically appropriate or not, where reasonable minds can somewhat differ. Things that I would say fall into this category are orthodontia. So braces, certain dental procedures, along the lines of orthodontia, having teeth removed, spacers, sometimes filling cavities. I've seen disputes about whether or not somebody should have baby cavities filled or not if they weren't painful. Other things would be therapy, play therapy, talk therapy, DBT, CBT, group therapy, you name the type of therapy, equine therapy, whatever it might be for the child. And then some other issues that are medically gray would be like homeopathy versus nebulizers and inhalers or chiropractic care, things like that, that typically aren't covered 100% by insurance. So there would be some out of pocket expenditures made by the parents. In a lot of places, parents have joint legal custody. That's kind of the status quo or the default, which means that each parent would have equal decision-making authority and capacity as it relates to these types of medical expenses. A big one I've seen is orthodontia. For some reason, there are parents out there who think orthodontia is silly. Having crooked teeth isn't a problem. It's not medically necessary, so I'm not going to pay for it. Not per se my personal 2 cents on that, as I had braces, right? I had really crooked teeth, and in the 7th grade, people laughed at me. So like I'm all for braces if that's something that would make the child feel better, and if a doctor or dentist or an orthodontist is recommending them. So, but that we see a lot where somebody gets a referral for something, but the other parent says, hey, this is $5,000, $6,000, $7,000, and I don't want to pay for it. Well, again, the next step is going to be, how do we determine whether or not something is agreed upon? And if it's not agreed upon, what is the tie-breaking authority or the decision-making authority that would allow somebody to go out and get the thing, but then require the other party to pay for it or pay their share? That needs to be in there, because what really happens if parties just can't agree and we want to have a fight about it is we're back on motion practice in court. And you can't possibly run back on motion practice every time there's a disagreement on an expenditure or on a course of action for the child. And again, where these decisions are tied to money, that always makes them so much murkier, because, hey, if my kid has crooked teeth and I can get free braces, who's saying no to that? Like, absolutely no one anywhere. So that's where laying these things out in advance becomes so powerful. A lot of the medical stuff goes back to that decision-making authority, but above all else, if a child's in pain and one party believes in chiropractic care a lot, then that's going to need to be addressed in that initial custody order, that initial decree, because that's going to be an ongoing and continual battle and fight, right? If one person won't pay for it, but one person thinks it's a big deal, and it's the end all be all of pain relief in their eyes. So I would say on those medically necessary gray areas where decisions are tied to finances, the more detail you can lay out about what is agreed upon as far as appropriate courses of treatment and appropriate medical care for your children in your decree or in your initial custody order, the better. Because where somebody is like a little wishy-washy on a course of action anyways, now you're asking them to pay for it. You're headed for nightmare. Again, as with the sports and the extracurriculars, who is incurring the expense first? How long does the other person have to reimburse them? And what is the protocol for doing that? How are we paying for that? Is that coming out of HSAs? Is it we're Venmoing back and forth? So all of that needs to be made clearer so that the disagreements on it are fewer into the future. Then the third one, went back and forth a little bit about what I thought was most common. And it changes, right, when we have little kids versus when we have older children. So for little kids, a big issue that comes up is this idea of after school care, where kids go to compulsory schooling, right? Like regular elementary school all the way up to the sixth grade. Oftentimes they're a little too young to be home alone after the school day. And one parent might be using after school care and the other parent might not. Where we have just traditional daycare because you have somebody under school age, it's pretty well settled in the law in most states that that is a part of child support, this idea that everybody's going to contribute to the daycare. But where one parent maybe can get off early enough to pick the kids up after school and the other parent doesn't get off early enough to pick the kids up after school, which creates a situation where one person's paying for daycare and the other person isn't, there have definitely been disputes arise that I've seen where the person who's not incurring after school care does not think that they should be required to contribute to it. They think that if I'm able to get off work in time to go get them, then on my days, that's what I'll do. If you're not able to do it and not able to get off early enough to go get them, on your days, you need to pay for that care. Neither one is right, neither one is wrong, right? Neither perspective is right or wrong, whether you think the person who incurs the cost should just pay for it or whether you think it should be split between the parties. Neither one is right or wrong, right? But it is a matter of it needs to be talked about in advance because all it's going to do is breed conflict into the future if it's not decided before these issues come up. So that's for younger kids. For older kids, we see a whole different slew of issues that arise about the time they start getting cell phones and are able to drive cars. These are big expenses. The cell phone issue, honestly, you guys, I could have made the cell phone issue and the car issue videos unto themselves, but I'll just talk about each of them briefly here in this last section and say that the cell phone issue becomes a big problem when it comes time to pay for it. And the argument against paying for it tends to be, well, I don't think the child is even old enough to have a cell phone in the first place. So that comes up a lot. And turned a fee dispute into more of a dispute about legal custody decision making about when is a child old enough to do one thing versus the other. Then you have like who's going to buy the phone, who's going to maintain the phone, who's going to repair the phone, and what is the cost month over month on the phone bill attributed to the child. And last is when we talk about buying cars. Again, there are often disputes about whether or not a child should then have to pay for their own car, whether they should have to pay for their own gas. Are they paying for their insurance? Should they even be allowed to get a car? How often can they use the car? And all of those things. And again, tied to money, right? If somebody buys the car and the other person thinks it should be on the child to buy the car, are they likely to contribute to the cost? No, they're not. So you need to define early on in your divorce and custody proceedings is the obligation of the child to get a vehicle? What is the obligation of each parent for that vehicle? And include things like who's carrying the insurance for the child? What is the child or the parent's contribution? Same for gas and general maintenance and repairs. These can be big fights, especially between like who's gonna provide the insurance, who's getting a better rate, who's got a bigger discount, and things like that. So doing the legwork early instead of trying to do it unilaterally and causing issues or not giving the other party notice. And it's just one of those things with such a big purchase that can raise a lot of concerns and a lot of fights and a lot of disputes between parents when the time comes. This and so much more need to be addressed in every single parenting plan. That's why we developed the parenting plans that protect workshop. One of the live ones is coming up on October 16th. I would love to see you inside of it if you're able, because you're watching this video before that time. But if you found value in this video, make sure that you like it and that you subscribe to my channel so that you never miss an update from me about all things custody, divorce, and co-parenting. See you in the next video.